Good day everyone. So in a community in Delta State, hooligans hijacked the Ozoro Festival of Fertility. So I'll be giving a legal analysis of what happened. However, I think it's prudent to begin with a legal analysis of customs. And the judicial authority I'll be relying on is the case of Abba versus Okobue. The legal principles adopted in that case can be deductively applied for the purpose of understanding the law and applying it in the context of the Ozoro Festival of Fertility. Now, the principles regulating cultures in Nigeria are as follows. Keep in mind that all these principles I'm outlining are interdependent. So the first principle is that cultures are validated by historical antecedents. That is, they are passed down from one generation to the next. Secondly, customs will be legally recognized by courts only if they are consistent with the Constitution and other relevant laws of the Federation. Thirdly, customs must not be inconsistent with public policy and the principle of natural justice, equity, and good conscience. Fourthly, customary practices are not a matter of speculation. They must be proved by evidence to the satisfaction of the court. The fifth principle is that customs must not condone the violation of the rule of law or constitutionally guaranteed human rights and liberties. The sixth principle is that customs are jurisdictionally restricted. That is, they are limited to a specific area which is occupied by the indigenous people that practice it. The seventh principle is that customs are enforced based on the principle of freedom of contract. Hence, customs are applicable only to people who consent to their validity, and also those who subject themselves to its application. That is the same thing. So it's validity as well as applicability. So the validity as well as applicability of customs are all a matter of consent. Moving on to the seventh principle. This seventh principle is very important and is also very relatable to the Ozoro situation. That is why I've saved it for last. The seventh principle is centered on adaptability. And I'll read a quote from the case to explain that. That is the case of Abba versus Okobue. Now I'm reading a quote from the case. When a customary law is confronted by a novel situation, the courts have to consider its applicability under the existing social environment. Thus, the doctrine of repugnancy affords the courts the opportunity for fine-tuning customary laws to meet changed social conditions. When customs are faced with a novel situation, the courts have to consider its applicability under the existing social environment. So customs have to adapt to the exigencies of modernization and urbanization. The issue is that the Ozoro Festival of Fertility was all about performing rituals on women who had childbearing issues. And the rituals were to be performed while a curfew was imposed on other females who were not involved in the ritual process. So in the most current instance of the festival, which I guess happened about a week ago, non-indigenous women who were reportedly students didn't observe the curfew, most likely because they were not aware or conversant of the customs of the Ozoro people. While they were carrying out their activities and exercising their freedom of movement, they were reportedly assaulted by hoodlums. That is, indigenous hoodlums in quotes. That is the reason, the core reason behind the whole social outcry and activism for the abolishment of the Ozoro Festival of Fertility, mostly on social media, that is. So these women were assaulted by hoodlums during the curfew, which most of them didn't know was enforced. That is not a complicated issue because those hoodlums are criminals, so they should be incarcerated. Their actions were ultra-vires and they were also carried out without the consent of the traditional ruler. Those atrocities were carried out without the consent or affirmation of the traditional ruler. So their actions were ultra-vires and criminal. So there's nothing complicated about that. They should be arrested, put on trial, and those are criminal acts. It's a criminal offense, so they can be charged under the relevant laws, and that's that. However, on the issue of the Ozoro Festival of Fertility, which is civil and bordering on the right to cultural life, in regard to the rituals, the festival of fertility, is factual that performing such rituals on women who consent to the practice is not an illegal act. So the Ozoro festival of fertility is actually a valid customary practice so long as the women who partake in these rituals actually consent to the performance of the rituals. However, imposing a curfew is incompatible with the urbanized and cosmopolitan nature of the community as of now, because non-indigenous students now live there, so that aspect of the custom should be reconsidered. So my recommendation is that maybe such rituals can be limited to a town hall or secluded area of the community where it can be performed without interfering with the rights and liberties of non-participants or other non-indigenous people who live there for the purpose of either work or education, as the case may be. So that is that. And this recommendation is obviously in line with the case of Abba versus Okogwe, which is centered on the legality of customs based on the principles already outlined in the initial stages of this discussion. So that is all about culture, legalization of customs based on the 7 principles I mentioned, in line with the judgment of the court in Abba versus Okogwe. So the bindingness of customs are legally a matter of consent as far as the consent to the cultural practices, and the cultural practices don't lead to the violation of the rule of law or constitutionally guarantee the rights of people, and all those who participate in the culture are doing it voluntarily and they consent to the validity and applicability of the custom, then the customs can be judicially recognized if there is any litigation considering the or involving the validity of the customs.